This video is going to discuss Rule 112, and that is your preliminary investigation. So for you to recall easily some of the provisions of your Rule 112, let us take a look at the cases of Miss Denise Cornejo and Miss Ana Halandoni. Let's study Rule 112 through what happened to the both of them. So we start with what happened to Miss Ana Halandoni. Miss Ana Halandoni sought first the help of her friends. She texted some of her friends together with the text is a picture of herself. Is a picture of herself. So because of this text, authorities were alerted according to the report of Mr. Nico Bawa. And since authorities were alerted, they immediately went to the scene of the crime and they immediately arrested the boyfriend, the then boyfriend, Mr. Thompson, and he was detained. Initial reports revealed that Mr. or Miss Halandoni and Mr. Thompson checked in at the hotel and they had a fight. So Halandoni alleged that Thompson, the boyfriend, mauled her, resulting in multiple injuries in various parts of her body. So why was Mr. Kit Thompson immediately arrested? Because the case falls under Rule 113, Section 5. That is an example of your warrantless arrest. Letter B, an offense has just been committed, and when the police officers went to the scene of the crime and they started investigating Miss Halandoni, tinanong siya, sino ba ang nambugbog sa'yo? And Miss Halandoni pointed out that it was her boyfriend, then the police officers already have that probable cause to believe that Mr. Thompson, the person to be arrested, has committed it. So what happened next? Mr. Thompson was delivered to the nearest police station or to the nearest jail, and he was proceeded in accordance with Section 6 of your Rule 112. Ano ba yang Section 6 of your Rule 112? When a person is lawfully arrested but without a warrant, then the complaint or information may be filed by a prosecutor without need of the PI, provided an inquest has been conducted in accordance with existing rules. So what happened to Miss Halandoni is there was an inquest. So we will discuss inquest in the following videos, but for now just take note that this is the proceedings that was used in the case of Miss Halandoni. So more or less you can say that in the case of Miss Halandoni, justice was already served. He attained justice immediately, if that is the goal, because Mr. Thompson was immediately brought to the police station. Let's now go to the case of Miss Denise Cornejo. Magkaiba so, as to what happened to Miss Ana Halandoni. So the case of Miss Denise Cornejo is something that you do not want your children or your loved ones, or especially you do not want to undergo that one. Bakit? Kasi napakasalimuot. Nasa initial stage pa lamang sila, nasa preliminaries pa lamang sila, pero ang tindi na ng pinagdaanan, ang dami ng perang nagastos, na-stress ka ng sobra. So, on 2014, Miss Denise Cornejo filed a complaint. And according to that complaint, she said that she was raped by Mr. Vong Navarro. So her complaint was raffled. It was assigned to an assistant city prosecutor, and the assistant city prosecutor issued a subpoena to Mr. Vong Navarro requiring him to submit his counter affidavit. So, ginawa naman yan ni Mr. Vong Navarro, nag-submit siya, and then there was a clarificatory hearing. But after that, a decision was rendered, and according to the investigating officer, walang basis ang complaint ni Miss Denise Cornejo. So, it was dismissed. So this decision of the investigating officer should be reviewed because that is the law. This was reviewed by her boss, the city prosecutor, and according to the boss, tama ang naging desisyon ng investigating officer, i-dismiss nga yan. So Here, sino ang nanalo? Sino ang masaya? Obviously, it was Mr. Vong Navarro. Kung ikaw si Miss Denise Cornejo, for sure, galit na galit ka kasi kung totoo nga ikaw ay ni-rape, natalo ka pa. Nasa initial stage pa lamang. So, what she did is she filed a petition for review. She appealed the case to the Department or to the Secretary of Justice. But ano ang naging decision ulit ng SOJ? The case was dismissed. So, tingnan mo yung pinagdaanan ni Miss Denise Cornejo. Talagang magagalit ka or talagang manlalantak ka. So, again, aggrieved, what she did is she filed a petition for certiorari to the Court of Appeals on the basis of grave abuse of discretion. And what was the ruling of the CA? The CA reversed and set aside the resolutions issued by the DOJ, and it ordered the city prosecutor of Taguig City to file rape and acts of lasciviousness charges against Mr. Vong Navarro. So this case was filed in 2014, and this is today is now 2022, almost 2023 na, 3 months na lang. So, just imagine kung ano yung pinagdaanan ni Miss Denise Cornejo just to get that glimpse of justice that she was seeking. Just imagine that one, and to think nasa preliminary stage pa lang sila, nasa step 1 pa lang sila. So the proceeding that we discussed in the case of Miss Denise Cornejo is what you call the preliminary investigation. Kaya pag binasa mo yung definition ng preliminary investigation, that is your section 1, it is merely an inquiry. It is merely an inquiry or proceeding to determine whether there is a sufficient ground to engender a well-founded belief that a crime has been committed and the respondent is probably guilty thereof and should be held for trial. Take note ha, in the case of Miss Denise Cornejo, Mr. Vong Navarro is not yet an accused. He is a respondent. Kaya pag binasa mo yung mga pleadings nila, nakasulat doon, Denise Cornejo as your complainant, she being the offended party, versus Vong Navarro, the respondent. Hindi pa yan people of the Philippines as your complainant versus Vong Navarro as your accused, because again, this is just an inquiry, hindi pa to umaakyat sa court. This is just the preliminary stage or the first step. Take note also that when the prosecutor dismissed the case of Mr. Vong Navarro or dismissed the case of Miss Denise Cornejo, it says that according to the investigation of the investigating prosecutor, there is no reasonable ground to believe that the crime of rape has been committed and Mr. Vong Navarro is not guilty thereof. So yan ang ibig sabihin dyan kung i-dismiss mo yung case, because if you find a probable cause, what you will do, investigating prosecutor, is you will hold the respondent for trial, and then you will prepare the resolution and information. And pag prepare mo yung information, you are certifying that a crime has been committed and the respondent is probably guilty thereof and he should be held for trial. That is the opposite in the case of Mr. Vong Navarro. Who are the officers authorized to conduct preliminary investigation? Answer is, you have the provincial prosecutor. Ito yung sa mga province of Leyte, sa Mountain Province. So they are called provincial prosecutor. And then you have the city prosecutor if you are situated in Cebu, in Davao, or in Manila, Taguig, and their assistants. And you have the national and regional state prosecutors and other officers as may be authorized by law. Take note of your administrative matter number 05826, Supreme Court, that is amendment of or amending Rule 112 of the revised rules on criminal procedure by removing the conduct of PI from the judges of the first level courts. Take note ha. So yung mga judges ng MTC, either municipal or metropolitan, they no longer conduct PI. So who are these officers authorized by law to conduct preliminary investigation? First is you have the COMELEC officials. So as regards COMELEC, no less than the 1987 Constitution tells us that the COMELEC has the power to investigate. Section 2 is very clear. Section 2 of your Article 9 says that the COMELEC has the power and the function to investigate violations of election laws, including the acts or omissions constituting election frauds, offenses, and malpractices. And if you're going to read your Omnibus Election Code, that is your BP Bilang 881, very clear that the Commission shall have the exclusive power to conduct preliminary investigation of all election offenses. But just take note though that this section has already been amended because of Section 43 of your RA 9369. According to the amendment, the Commission now have the power, but concurrent with the other prosecuting arms of the government, to conduct PI of all election offenses punishable under this code and prosecute the same. So aside from COMELEC, who are the other officers authorized by law to conduct preliminary investigation? That is your ombudsman. Concerning ombudsman, take note that these are, or the ombudsman is the protector of the people. That is very clear according to Section 12 of the 1987 Constitution, Article 11, the accountability of public officers. So when the ombudsman receives a complaint, take note that the complaint can either be a verbal complaint or a written complaint, because it is very clear that the complaint filed in any form or manner and against a public official or employees of the government, that includes yung mga nagtatrabaho sa GOCC, any subdivision, agency, or instrumentality of the government, then the ombudsman can investigate. They can investigate because that is one of their powers, functions, and duties. Section 13 is very clear. Section 13 of Article 11 of the 1987 Constitution. Take note ha, that kahit nga walang complaint, ombudsman can investigate on its own. Kaya pag merong nag-viral na video, like for example, an executive secretary pumunta sa casino sa Soler, nag-viral, si ombudsman, kahit walang magreklamo, it can investigate on its own because that is their function. Other officer authorized by law to conduct PI aside from your COMELEC and ombudsman is the PCGG. So as to PCGG, they have the right to investigate involving the acquisition and accumulation of ill-gotten wealth of these people. Take note that PI is required to be conducted before the filing of the complaint or information. Before the filing of a complaint or information, dapat magkaroon ng PI. Kaya yung dinidiscuss natin na case kanina ni Miss Cornejo, imagine what she went through. Nasa first stage pa lang, nasa step 1 pa lang, nasa preliminary step pa lang, ang tindi na ng pinagdaanan niya. Hindi pa nga umaakyat yung kaso sa korte. Nasa preliminary stage pa lamang siya, pero ang tindi na ng stress, ang dami ng lumabas na pera, ang tagal pa ng desisyon. Umabot ng almost 10 years. Just take note though that not all cases undergo preliminary investigation because there are cases wherein PI is not required. So when is PI required? Answer is the penalty must be at least 4 to 4 years 2 months and 1 day. Basis, that is your second paragraph of your section 1 of your Rule 112, a PI is required to be conducted before the filing of a complaint or information for an offense where the penalty prescribed by law is at least 4 years, 2 months, and 1 day without regard to the fine. Question: lahat ba ng kaso sa RTC dumaan sa preliminary investigation? Answer is of course, definitely. Bakit naging of course? Because for a case to be filed in the RTC, ano nga ba ang penalty dyan? Dapat 6 years and 1 day. Kasi ang jurisdiction ng RTC is for offenses wherein the penalty is at least 6 years and 1 day. Kaya, very safe to say that lahat ng cases sa RTC dumaan sa preliminary investigation. How about in the MTC? MTC cases. Pagdating sa MTC, you have to qualify because not all MTC cases will undergo preliminary investigation. Only those wherein the penalty is 4 years, 2 months, and 1 day that preliminary investigation is required. Kailan naman walang preliminary investigation? Of course, the opposite. If the penalty is less than 4 years, 2 months, and 1 day, then you do not need preliminary investigation. At of course, sino ang may jurisdiction? MTC. MTC. So ano ba ang mga examples ng less than 4 years, 2 months, and 1 day na mga cases? Example is the malicious mischief, that is only arresto mayor. And then the other one, the case filed by Vong Navarro against Cedric Lee, yung grave coercion, that does not require preliminary investigation. Recall your Rule 110, Section 1. How do you institute a criminal case? Well, if that requires a PI, meaning to say the penalty is at least 4 years, 2 months, and 1 day, then what you need to do first is to file a complaint with the proper officer for the purpose of conducting the required PI. Take note that itong proper officer, it could be the prosecutor. Kung election offenses yan, then go to the COMELEC. If it involves the public officers or public employees, then go to the ombudsman for the PI. How about if the case does not require PI, then you have two options. You can institute your criminal case by filing a complaint with the office of the prosecutor, or you can direct file with the MTC. That is your letter B of your section 1 of your Rule 110. But if you are in Metro Manila, ano ang sabi? You have no other choice. You have no option but to file your complaint with the office of the prosecutor. Take note that if you are only in Manila and other chartered cities. So what is the procedure if your case requires a preliminary investigation? The answer is the procedure is the one laid down in Section 3 of Rule 112. The entire Section 3 from letter A to F. Yun yung diniscuss ko kanina dun sa nangyari kay Miss Denise Cornejo. But I will discuss that in detail when I go to the next video. So, how about if the case does not require a preliminary investigation? Diba, pag hindi kailangan ng PI, then you have two options. Either you can file your complaint with the office of the prosecutor. So, in that case, what is the procedure? The procedure is only Section 3A of your Rule 112. What is the basis? You go to Section 8 of your Rule 112. If the complaint is filed directly with the prosecutor involving an offense punishable by an imprisonment of less than 4 years, 2 months, and 1 day, then the procedure outlined in Section 3A shall be observed. How about if the course of action is direct filing with the MTC? Then what is the procedure? Answer is the same. Section 3A basis. If the complaint or information is filed with the MTC, then the procedure in Section 3A shall be observed. take note ha that the same yan when we talk about summary procedure. Only Section 3A kasi very clear naman sa Section 8 that for cases not requiring a PI nor covered by the rule on summary procedure, then only Section 3A and not the entire Section 3.